Hello friends, today we are going to discuss different articles and chapters which are available in Uncitral Model Law. So what is Uncitral Model Law and why it came into the exist we discussed in last lecture to provide the legal recognition to the electronic exchange or to electronic transaction, that is e-commerce, to provide the legal recognition at that time in the 17 December of 1966. This act was created by the General Assembly, but now there are different chapters which are available and articles which are available in Uncitral Model Law. Now, chapter 1 describe the concept of general provisions. Now, next, uh, it with the sphere of application. In this, the data messages, electronic data interchange, originator and addressee, these are the things which is to be described and provide a legal recognition to that uh, personnel. Now next, article 3. Now next, interpretation. This law should be interpreted keeping in mind its international origin, the need to promote uniformity, and its application and observance of good faith. The question related to such matter which fall under the scope of this law but which are not expressly settled in, and it should be settled in conformity with the general principle which this law is to be based. Now chapter 4, variation by agreement. The provisions of chapter 1 and 2 which may be varied by agreement between the two parties, that is, for example, MOU, Memorandum of Understanding. So this may be varied by the agreement which are available between two parties. So what we can say that the sending and receiving and the storing and other processing data messages, what we can say that they at that time they as per their convenience and as per their electronic circumstances and electronic requirement which are available at that as per the two parties can change their the two parties can change their the things. A legal recognition of data messages and information which should not be denied a legal effect, its validity or enforceability solely because it is in the form of data messages. The data messages, article 6, the data mass article 6 is your writing. Article 6, data messages fulfill the requirement in places where the law requires, where the information is required, and in writing provided the data is accessible and usable for subsequent references. Now next, article 7. So these are the different articles and chapter which are available, and how the as per the electronic data messaging, electronic data exchange, that is the e-commerce, the from article 1 to article 14 different chapters which are available. Article 15, there are different time and place dispatch and receipt of data messages. So these are the few legal recognition which is to be provided by this unsettled model law. Now next, signature. So this signature is not the is this signature is providing the legal recognition for digital signature. Okay, the data messages can be used as a digital signature of a person. Now next, original. In place where the law is required information to be represented its original form. Now, Article 9, admissibility and evidential weight of data messages. What is the evidential weight and what was the information in the form of data message which shall be given due to evidential weight. Now Article 10, retention of data messages. Article 11, communication of data messages. Article 12, recognition of by the parties of data message. Article 13, attribution of data message. Acknowledgement of receipt. So these are the different articles which are discussed, and their legal recognition, which is to be what kind of recognition, legal recognition given to that electronic data message, which is to be discussed in this different article. Acknowledgement of receipt, whether the acknowledgement is given to sender or not. Time and place of dispatch and receipt of data message, whether it is happened or not. So these are the few things which are discussed in unsettled model law. So this law, which is to be amendment in uh, which was developed in 17 December of 1966. So main reason of this law, which was to promote the progressive harmonization and unification of the international trade law. But the main reason to came into the exist is that whenever the electronic transformation or electronic transaction which was available at that time, this law provide the legal recognition to them. Okay, thank you.